although I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my rights.
Ma'am.
Right away, you can tell this hearing was never going to be normal. The second she starts talking about living souls and straw men, the courtroom shifts from a standard contempt hearing into a full ideological battle. And the judge already sounds like someone who's dealt with these arguments before.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. A show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it. Says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
Failing to appear for order to show cause on Wednesday.
What makes this case so intense is that the judge isn't reacting emotionally at first. He's actually trying to slow everything down and explain procedures step by step. But she's approaching the courtroom like the entire legal system itself is illegitimate. That creates a collision that almost guarantees conflict.
for you.
Ma'am,
Okay, now,
just understand what the judge asked you regarding those 2 charges.
Did you just understand that I think there's a bigger overriding issue? Thank you.
Wait, hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank
you
you.
and Ms. Bridges.
I just like to, state that
well, I think,
those, and that she would like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
no, but all of my rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She was working, okay,
Okay, you're going to get your
Mr.
hearing.
Villanueva,
No,
I
this
direct you to
is-
stop
thank you.
arguing with Ms. Bridges.
Okay.
I mean, it's
The cut-up court order becomes a huge turning point here, because from her perspective, it's some kind of symbolic rejection of jurisdiction. But from the court's perspective, it looks like open defiance. That difference in interpretation changes everything. Us.
But anyway, that's for the later hearing. So
well, she was investigating, okay.
Today's purpose is to advise you of the 2 contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask, what statutes or what law or what are you saying here are the charges? Because this does not match, sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay? It does not say.
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
Why have they changed,
I'm
Judge
not
Beck?
answering that question.
Can the prosecutor?
No.
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes,
Okay.
I do.
If you want to do that you know what the penalties are and what your rights are, and I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those?
then I'm going to appoint
I'm not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so I'm asking you, and you saw what
How
happened,
can I
Ms. Bridgman. So I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and or $7,500 fine. You understand it.
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any questions?
The whole question about the whole context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it and say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh,
Notice how she keeps demanding statutes and codes while also rejecting the authority of statutes and codes at the same time. That contradiction is why these hearings spiral so fast. The court operates on procedure, while sovereign-style arguments usually reject the legitimacy of the procedure itself.
request a trial by jury.
There is no right to trial by jury in contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay,
I'm not gonna argue about what-
and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one, and this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items check marked here.
This is after the fact, so then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do,
All right,
okay?
all right.
Now,
I'm going to find that,
what please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one,
Would you generally like to see what she has
But-
here?
I just, so you
okay,
don't,
so how do I defend?
hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor,
Oh, sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then.
So- Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today, we're going to schedule a hearing date, and you can present that evidence at that time.
And how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury.
for a
in
contempt charge?
So I
Oh,
can
so
schedule
this is a perfect, nice little tidy package.
The moment she learns there's no jury trial for contempt, you can actually hear the frustration rise. She clearly feels boxed in by a system she already doesn't trust. And honestly, whether people agree with her or not, being arrested overnight over something you believed was invalid clearly intensified her emotions.
On Thursday, January 25th, at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long as I'm convinced that you're doing so of your own free choice, that you understand what's going on, and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath, yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
if you want to subpoena somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena, they would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at Vine League and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out.
Being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond, I mean,
okay, I get it, Judge Gothier, I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
hearing
codes and
on both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Bridgman is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training and researching the case law, interpreting what that is on yourself. You're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want to appoint an attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been down that path before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yeah, Ms. Bridgman, if you want to represent yourself, it's a little bit more work.
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with, or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
those
thank you.
Arguments, and the prosecutor will present witnesses at that hearing, and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf, submit a subpoena to the clerk's office that I would review. It'd be the district court office
Okay.
that I would review, and I would issue the subpoena.
This is probably the most important part of the hearing. The judge is practically warning her that self-representation is dangerous. He explains subpoenas, evidence, witnesses, and legal standards. But instead of focusing on defense strategy, she keeps returning to constitutional philosophy and common law arguments. The ZIC.
Any input, Mr. Gillenway?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf.
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability. So she informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that there's no drug or alcohol issues. Granted, there's this allegation of not appearing at I believe, within the Sheboygan County for that. And so I advise that Your Honor, and one last thing, she's a politically active member in the community. She has audited an election previously. So I believe, she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that that's by the fact that she cut off the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they didn't.
It wasn't an offer, it was an order.
Sorry.
To appear.
They didn't actually hand it to me.
Just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety of the full amount. There'd be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know if you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was...
And in the end, the judge's patience starts running out. The bond decision tells you the court no longer sees this as confusion. They see it as intentional refusal to comply. That's the real divide here. She believes she's defending rights, while the court believes it's defending authority and procedure.